May it please the Court?
Good morning.
Good morning, Your Honors. Melissa Giassi. I'm here on behalf of the appellant, Iran Rodriguez. We're here today asking the Court to reverse what we feel are two erroneous rulings made by the trial court. But I do want to start out by saying that I think there are some bigger issues in play based on the record in this case, and what the Court has in front of it is essentially a strategy of trial counsel to pursue the dismissal as a sanction. And so I think that I needed to frame the events of the case, and obviously we did so in the briefs. So I feel very strongly that the summary judgment was entered in error, that the complaint stated a cause of action, there wasn't an answer filed, but obviously that ultimately ended up being a non-final order because the trial judge did provide leave to amend. But if this case is reversed, as we think it should be, that same issue is going to be before the trial court. The sanction motion started when there was a motion for protective order filed based on a deposition that admitted...
Let me go back to the jurisdictional aspect. The fact that the court granted you leave, is it your position that this is a non-final appealable order?
No, Your Honor. There was a final order dismissing the case as a sanction, and I think under the appellate rules, the orders that, led up to, it opens the door for your review of any non-final orders.
Because that's what I think is more appropriate. But I thought I heard you say that you believe that there's a non-final...
No, ma'am. I am also challenging the summary judgment ruling that happened before the case was dismissed as a sanction.
Okay. I think I understand you now. All right.
No.
The summary judgment ruling, right, was that there's no private right of action under 627-428. Is that correct or not?
Yes, that is correct.
Why does the filing or not of an answer matter to the trial court's ability to adjudicate that issue? I mean, this isn't an affirmative defense like waiver or estoppel. In other words, it is not the admission of everything the plaintiff has alleged and the assertion of some other matter. It's saying the claim that the plaintiff has asserted as a matter of law does not exist.
Well, I agree, and I think it's failure to state a cause of action and maybe should have more appropriately been brought as a motion to dismiss. However, the failure to file an answer could impact the other four summary judgments that were pending at the time of the entry of the sanction order, which most certainly will be pushed forward by trial counsel without filing an answer. So maybe not necessarily for that particular summary judgment motion, but taking a step back from that, I'd like to make sure the court's aware of the fact that the lawsuit was not for breach of the statute. The lawsuit was very clearly for breach of contract. And that exact, the policy tracks the language of the statute. I think if you look at the count, breach of contract, it specifically says that the payment wasn't made within the time frame of what was provided for in the policy. And the policy provision is on page 834 of the record, and it just says, within 90 days after we receive notice of a claim from you, we will pay or deny such claim or a portion of the claim unless the failure to pay such claim or portion of claim is caused by factors beyond our control which reasonably prevent such payment. So it's right there in the contract. This is a case where the loss was reported, the insurance company had a chance to inspect. There was a over 4-hour examination under oath. There was a last correspondence sent to the insurance company saying, do you need anything else from me? There was no response. And then at that point, based on the fact that they had well exceeded the 90 days and there was no reasonable circumstances explained to the insured that would prevent payment, the lawsuit was filed. And it's...
Let me lead you to the sanctions part of it, if I may. Because in looking at this record, it appears that, and there was the hearing before Judge Rice, and at that time, what was represented to her is the fact, I think it was very clear that the judge was upset with the fact that information was provided to her that the clients were out of the country, and in essence, they were not out of the country at the time all this deposition took place. But my question is, the actual final order with the sanction that lists out all the Cazals had other information regarding other cases. Was that presented at the hearing? Was that something that you were placed on notice that the court was going to consider these other matters? How did all that come about?
Well, so we started with the emergency motion for protective order.
Correct.
And at that point, and it was filed after an unsuccessful attempt to request a professional courtesy from trial counsel for defendant. And at the motion for protective order, the judge was not specifically advised of the illness of the appellant's father-in-law. However, she was advised that they had plane tickets, that they were going to be out of the country, and that it would be an undue burden and expense for them to have to reschedule.
She was also advised that this is notice for, this had been part of a long-standing effort to get this deposition set and scheduled, that the deposition had been noticed for 3 months, and that it's 2 days before the deposition is supposed to take place, that we're litigating a protective order motion. She's also aware that the motion represented that the plaintiff was already out of the country. She found out at the hearing that the plaintiff was or was at least told at the hearing that the plaintiff was actually in the country and wasn't scheduled to leave until the next day, so she could put the genie back in the bottle were she so inclined. Why is there an abuse of discretion on those facts?
Well, she was, and again, she was told right at the beginning of the ultimate evidentiary hearing, maybe there wasn't an abuse of discretion on, at the, flowing from the hearing in July on the denial of the motion for protective order. But I do want the court to be aware of the fact that at the end of that hearing, Judge Rice did not order them to appear. She said that based on the proffer of facts that had been given to her at that point in time, she was denying it and said, look, your clients are going to have to make a tough decision. So she denied the motion for protective order, and the rules provide for consequences if a party deponent does not show up for deposition. So, I think on that level, she left the consideration of it open to additional facts, which were certainly presented at the latter hearing.
Well, let me interrupt you. Well, if I may.
Sure.
There's a motion for protective order asking the judge, please, judge, relieve the requirement, because your client was kind of unusual. Your client was actually subpoenaed to appear, correct?
Yes, ma'am.
And usually for parties, you don't have subpoenas. Usually there's just a notice to set that individual for deposition. But so you have your client who was subpoenaed to appear the following day. You have a hearing in front of the court on the motion protective order saying, please relieve my client from the obligation. The court denied that motion protective order. By denying the motion protective order, comes to the conclusion the subpoena still stands, your client is required to still attend. She didn't. The judge did not say the words, "Oh, your client shall appear." So I think there's a bit of we have to be careful. I mean, the bottom line is your client was still under subpoena to appear at the deposition the next day.
Yes.
And he failed, or they chose not to show up.
I agree, and what she actually said is, he's just going to have to accept the consequences of the motion, of his actions, and going to deny the protective order. And then, they go on to discuss the different relief that trial counsel for Avatar intended to pursue. And again, at that point in time, she does make it clear that she's denying it on that proffer of facts. Well, there were a very different set of facts proffered to her at the evidentiary hearing that was held in May, where both Mr. Rodriguez and his wife testified that the mother was gravely ill, that they were concerned that she was at death's door, that family was very important to them. So arguably, even at that point, she had left it open for reconsideration of her earlier ruling. But, and as far as, her frustration with perceived misrepresentations, I don't think that it's material to say that they were already out of the country. There's no question that they were going to leave the country on the day of the deposition. So
why did the attorney send an email saying they were out of the country?
maybe he got, as far as the record goes, I think,
Apparently there was something going on between the a civil basis.
I think that there's some hostility between trial counsel, but,
I mean, they apparently didn't get along at all.
right, and so, unfortunately,
When you fudge the facts, you're only making things worse.
well,
And the judge doesn't have to overlook that if she didn't want to.
well, she maybe, but she certainly, I think if you look at the very beginning of the hearing that was held on the order to show cause, which again, we're kind of missing some of the big picture issues here. This case got dismissed after the plaintiff and his attorney were ordered to appear to show cause why they shouldn't be held in contempt. And then this Cosell order was entered. So
Well, that's what I'm trying to find out, because at that order to show cause, based on the case law, your client is given an opportunity to basically the judge will have to determine should that person be held in contempt for violating a subpoena. Was there was a lot of other stuff brought in to the court on other matters. Was that proffered? Was that just by argument? Because the order, ultimately, the order of dismissal with prejudice listed all these other issues and other cases involving
it was proffered to some extent. It was discussed. I don't, there were no exhibits to the hearing transcript. The orders, I believe, might have been filed under separate cover, but again, there was nothing, there was no motion pending before the court at the time of the May hearing that asked for the imposition of the ultimate sanction of dismissal.
So your objection is not that the order, as I understand your argument, you're concerned with the fact that, yes, the court had an order to show cause hearing that was inappropriate to leap to the ultimate thing of dismissal, that there should have been another hearing in between to determine about the ultimate dismissal with prejudice?
Or a motion filed asking for that relief? There was nothing. So not only were the plaintiff and his trial counsel at the hearing in May of 2017 just expecting to deal with the fact that they had not appeared at the deposition and that the trial court had the authority to either order them to appear for deposition, award fees and costs, and I think...
So basically your argument is a due process failing, you all were not placed on notice.
No notice. I think the notice that my opponent points to is a mention by trial counsel for Avatar at the motion calendar hearing where they obtained the special set date for the order to show cause hearing, that he said that he intended to ask for dismissal under Cosell. Well, I would submit that that could be read
Is the transcript of that UMC hearing in the...
Yes, Your Honor.
It's in the record?
Yes, Your Honor.
Okay.
But I don't think that that's the same thing as asking for dismissal under Cosell. You can say that you're going to do that, and I would...
There was no written response filed to the motion for contempt.
I believe it was filed, but it was filed belatedly. But again, they appeared to testify, both of the clients, and I think trial counsel explained that repeatedly to the judge. Look, we're here, and I think...
Well, the judge at the hearing said this is an intentional snub. They're going to do what they want to do regardless of what I order. That was a kind of a finding of fact at the hearing. The judge took it under advisement and allowed both parties to file memorandum, which they did, and 2 months later is when you got the dismissal. And the judge went through the Cosell factors. You're at 6 minutes. You didn't tell me, but you wanted 5 minutes for rebuttal.
I think that some of the, if you're looking at the actual transcript, maybe, but I think a lot of the quotes in the final order were very much taken out of context. And, we don't even get to the Cosell factors or the potential for dismissal until that relief is requested and until my client and trial counsel were given, opportunity to be heard and notice of the fact that that was an issue. I mean, I have, multiple, issues with the evidence that was presented that don't support the findings made in the final order, but, I don't think that we even get there based on the fact that we appeared before Judge Rice on an order to show cause dealing with the issue of contempt on the deposition. And I also think that, and then I'll reserve the rest of my time for rebuttal, these events occurred in July of 2016. And then there were those 4, extensive summary judgment motions filed. I think the page count exceeded 1,400. And at no point was there an attempt by trial counsel for Avatar to redepose Mr. Rodriguez. If that deposition was so crucial, and we've cited multiple record sites in the briefs where he repeatedly says he doesn't need the deposition. He doesn't need the deposition. So, I just think that in the big context of the events as they occurred in this case, just make the opposition to the motion for protective order unreasonable, the way trial counsel for Avatar argued the motion for protective order was a little disingenuous, and then here we are after no notice, and my trial counsel had to beg for his clients to be able to, give 2 minutes of testimony each at the hearing where they didn't know they were facing the sanction of dismissal. Thank you.
I'll save you 4 minutes for rebuttal.
Thank you, Your Honor.
Good morning. May it please the court, Carol Rooney for the appellee Avatar. There's really discrete issues presented on appeal today, but I'd like to start out with stressing how important the standard of review is in this case. First of all, the judgment is presumed correct, and the appellant has the burden of showing whether or not Judge Rice abused her discretion, and they clearly have not met that burden.
And if I may, Mr. because one of the things that your opponent mentions, which is a bit concerning, almost like a lack of notice, went in for a hearing on an order to show cause. Clients, even though, it's pretty flagrant, you have a hearing on a motion protective order, the judge denies that. It's almost basic 101, you shall appear. And it appears that they decided to still go out of town, which I would imagine vexed the trial. Maybe that's a strong term, upsetted the trial court. But on an order to show cause, whether or not the contempt issue, and then it leaps over to dismissal with prejudice. Look at all the bad things that their firm have done in other cases and how much prejudice you poison the trial judge. Look, they did this in this case, they did that in this case. Well, that's all well and good in these cases, but how about the case here? That's my concern. And as you know, a dismissal with prejudice under Casualty, that's pretty final, and that's pretty. So help me out and tell me why I should not be concerned with their argument that really it was a lack of notice. They didn't have the due process. They didn't have the opportunity to present saying, hey, you shouldn't look at all this other stuff. Look at the facts here.
Certainly, Your Honor. First of all, March 28th hearing. Due process requires opportunity, notice and an opportunity to be heard. The March 28th hearing was where the trial judge...
Am I right? What was said at the March 28th hearing was quite... After a very long recitation of all the ways defense trial counsel felt he had been wronged, quite candidly, I'm going to be asking for a dismissal with prejudice based on this pattern of conduct. That can't happen today. I'm just asking for the issuance of an order to show cause so we can deal with it. Is that what you're relying on?
That's part of it. So then we have the order. The order is issued, and basically the judge refers to civil contempt and criminal contempt. Nothing is filed. This is in March. The order is issued in April. So counsel is on notice. Mr. Rodriguez is on notice that we're going to have a hearing in May, 2 months later, where all of this is going to be addressed, and Avatar's counsel has stated he intends to seek dismissal based on a pattern of misconduct, dismissal with prejudice. So they have notice. There's actual notice there. So then we get to the May hearing. Judge Rice, she's very concerned because here, and also I want to point out at the March 28th hearing, counsel's saying, well, they only had 2 minutes to testify. At that March 28th hearing, Judge Rice said, be mindful of time. Make sure you get the time that you need. This is not a 15-minute hearing. Go talk to my JA. Did counsel ever request, if you're going to have witnesses testify, wouldn't you ask for a couple hours, not 30 minutes? They agreed to this time, no objection. So that.
We have an awful lot of cases. I had 2 decided within the last year that I found, just very, very quickly that say, and I'll just quote, when a court considers issues not noticed for hearing, the court denies the litigant due process and any ensuing order or judgment must be reversed, right? There's no question that there wasn't a motion that sought the relief of dismissal. The motion sought an order to show cause, and it sought attorney's fees under under Rule 1.380A4. The order to show cause doesn't say that dismissal is on the table. So what makes kind of a passing reference in the context of a 5-minute UMC hearing kind of sufficient from a due process standpoint to tee this thing up?
Because the court has the inherent authority to dismiss based on a flagrant violation of a court order. And once you have that, there's your due process. I mean, they knew that they had violated this court order, that Judge Rice had interpreted this as a violation of the court order. They get to the May hearing, Judge Rice is practically begging them, tell me what to do. And I want to quote from this testimony. She says, okay, all right, but when the court has to make a call, and Kozel is extreme, the death knell, it's an extreme sanction, and it has to be supported by an accurate factual record and a detailed factual record. So if you're not giving me the details by which to refute anything Mr. Allen is saying, and so she's asking, they chose not to file anything in advance of this 30-minute hearing that they agreed to. Counsel says, well, I just intended to have them present testimony, 2 witnesses at a 30-minute hearing. She allowed it. And then even after the hearing, when certainly she said, counsel to both sides, submit detailed orders. Counsel, tell me why I should not grant dismissal with prejudice. There's no record at all of any detailed order submitted by the other side saying why she should not grant it. Avatar filed, Judge, you asked earlier, where's all the record of this? Because the court, Judge Rice indicated, I'm taking judicial notice and I'm going to review the court file. Avatar filed records of sanctions in other cases. All of that is in the record. So Judge Rice had that to review. They didn't file anything. And then even after this detailed order is entered, where's the motion to correct any of these factual findings? I mean, again, you have a responsibility, not only as counsel, but as a litigant, to make a record, to show that Judge Rice abused her discretion. She said over and over throughout the course of all these proceedings, tell me where I'm wrong, show me. I have nothing to go on. And there's nothing in the record, and that is utterly and entirely their burden. Again, the judgment here, this order is presumed correct. Even the authorities cited by counsel say an order of contempt is presumed correct unless there's a showing of abuse of discretion or clear error, and that's their burden to show that. They have not done so. Again, Judge Rice repeatedly said, show me where I'm wrong. I mean, nothing is ever filed. They agreed to a 30-minute hearing to present testimony. They can't really complain about 2 minutes when they agreed to a 30-minute hearing. So without question, due process has been satisfied. There has been absolutely no showing of abuse of discretion here. And so the order should be affirmed. If they haven't met their burden to show an abuse of discretion, then it should be affirmed. And getting to the summary judgment, the other case that Rodriguez presented was also made on the same argument that this was a private statute that does not provide a private right of action. That was affirmed. That was PCA'd in the other case. I think that was a correct ruling here. But quite frankly, the fact that the judge allowed leave to amend and we have 4 pending motions for summary judgment and a second amended complaint, whether the court even wants to go there, certainly it could be affirmed just on that basis alone. But I would request that this court not direct the court. If you decided to reverse the order, it should be up to the trial judge how they're going to handle the pending motions for summary judgment. But the complaint as pled was basically based on just a statute. It was undisputed that the claim was still being adjusted. There had been no denial. This court has said that a cause of action for breach of contract doesn't accrue until there's a refusal to pay. If you're still investigating, that hasn't happened. So I just wanted to point that out to the court. But unless the court has any further questions for me, I believe it's very, very clear that no abuse of discretion has been shown. That judgment is presumed correct, and it should be affirmed. Thank you.
All right, and you've got 4 minutes for rebuttal.
Thank you, Your Honor. As argued in the briefs, I don't think we're here just solely on an abuse of discretion review. I think to get to the abuse of discretion review, you have to agree that there was due process given. You have to agree that there was a motion filed asking for this relief.
Well, I mean, I think the due process issue ultimately boils down to whether or not this statement at the scheduling hearing was sufficient notice that the show cause hearing was going to be about dismissal. That issue isn't really joined by the briefs. I'd like to hear you on that.
Sure. Well, I think it is in the sense that I also argued that the sanction order was relief granted outside the pleadings, which is a separate due process issue. So maybe I broke the two up, but just a statement at a UMC hearing that he intends to seek the ultimate sanction of dismissal, I would reasonably assume that there would be a motion forthcoming. So the due process as to the fact that there was never a motion filed, that's due process in and of itself. There was never a motion filed asking for relief, and a statement at a UMC doesn't cure that due process deficiency.
But does that go into the issue of notice? I mean, the main reason you file a motion is to put the other side on notice. And if a party is placed on notice, isn't that what it boils down to?
Not from my viewpoint, Your Honor. I do think that there's twofold. You know, maybe notice and an opportunity to be heard are one thing, and there's plenty of cases cited in the briefs where, orders entered outside the pleadings or granting relief not requested by the parties are void as well for lack of due process. Whether or not, the actual motion was noticed for hearing. I mean, you could have a motion, to compel and then end up with a cause dismissal and have a notice of hearing on the motion to compel, and it's still a lack of due process. It's void. It's outside the relief requested by the parties. And as far as the argument that the trial court had the inherent authority to dismiss the case, that was not the issue before the court. She never made any findings that would support that argument for affirmance. A close read of the transcript, this poor appellant and his wife both testified very humbly, very apologetically, that they were put in a very, very difficult position. And at the earlier hearing on the motion for protective order, Judge Rice said that she was denying it based on the facts in front of her. And at that point in time, there was no testimony about the concern that they were going to lose the matriarch of their family, and that it was an undue burden, it was an undue expense on them to reschedule plane tickets that had cost $3,000. So even though those statements might have been made by the trial judge at the hearing, I think the record actually supports that plenty of evidence was presented to give her a reason not to dismiss the case, or what we thought we were there for that day was to avoid contempt, whether it be attorney's fees or...
You're down to about a half a minute.
No, I understand. And I don't think that there was a rehearing necessary. This wasn't an issue where the order didn't have statutory findings. This is a sufficiency of the evidence to support the findings in that extensive order. But I don't think we get there because I think it's void for lack of due process. I would ask this court to reverse the sanction order. I would ask for this court to note the inconsistencies between the sanction order and the evidence presented at the hearing. And I would also ask the court to reverse the summary judgment order that was entered, essentially saying that the complaint was brought based on the statutory cause of action.
You're out of time. Did you want to say anything else? 5 seconds.
Thank you, Your Honors.
All right, thank you very much. Well argued. Okay, we're going to take the Vecchio v. Vecchio case.